Ladies and gentlemen, welcome to the National Constitution Center. I am Jeffrey Rosen. I am the president of this wonderful institution. And since I started here at the National Constitution Center in June 2013, I cannot imagine a more exciting day than Bill of Rights Day, which we celebrate today. Before I start and explain why this is so hugely significant for the Constitution Center, for Philadelphia, and for the USA, I want to begin by reciting the mandate from Congress that the National Constitution Center is privileged to have. And many of you, I see familiar faces in the audience, many of you know it. We're live on C-SPAN all day today, so I just want to share this beautiful mission that we have with our C-SPAN viewers, and that is this. The National Constitution Center is a private nonprofit, but it was created by Congress on the bicentennial of the Constitution to disseminate information about the US Constitution on a nonpartisan basis. And that means that we are the only place in America in these polarized times that invites people from all sides of the spectrum, from the left and the right and everywhere in between, to debate not political questions, but constitutional questions, and let citizens make up their own minds. And as part of this inspiring mission, I can't imagine a more exciting and momentous event than the one we're celebrating today on Bill of Rights Day. And that is the opening of a new exhibit at the Constitution Center, which displays one of the 12 original copies of the Bill of Rights. Basically, George Washington, on October 2nd, 1789, sent out to the states 13 copies of the Bill of Rights and 1 copy to the federal government. 12 of those copies survive, and one of them is being installed in a beautiful new gallery today at the Constitution Center. It'll be open for the next 3 years. It includes rare original copies of the Declaration of Independence and the Constitution, and it tells the story of how the rights that were promised in the Declaration of Independence were implicit in the Constitution and finally codified in the Bill of Rights. And this is one of the copies that has been at the New York Public Library for 100 years, and thanks to a historic and beautiful agreement, the Commonwealth of Pennsylvania and the New York Public Library are sharing it for the next 100 years. So we have it for 3 years until 2017, the 3 years that coincide with the 225th anniversary of the proposal and ratification of the Bill of Rights. Then it goes back to New York for 3 years, and back to us, and we will trade it like a precious constitutional football for the next 100 years so that citizens from around the country and around the world can view this Bill of Rights, and they can also see this incredible new interactive we've installed where people can click on any provision of the Bill of Rights, see its historical antecedents in the Revolutionary period, and then watch the spread of that liberty to constitutions across the globe. You can check it out at constitutioncenter.org, and it's just a remarkable and visual experience of how the US Bill of Rights has influenced liberty around the globe. Ladies and gentlemen, I'm now just so excited to be inaugurating the first of 4 book talks in the National Constitution Center's first ever Bill of Rights themed book fair. We are so excited that this is broadcast live all day on C-SPAN, and we invite our great Constitution Center audience to write down their questions on note cards, and we invite viewers from around the country to tweet us your questions. Our handle is @ConstitutionCenter, ConstitutionCTR, and use the hashtag NCC Bill of Rights, and after we've talked for a bit, then I will take your questions. What's so great about these 4 books is they relate to each other in fascinating ways, and I'm so glad that we're starting with the question of free speech that was at the heart of the debates over the original Bill of Rights, and then we're going to broaden out to ideas about natural rights versus tradition, expressed in the thought of Thomas Paine and Edmund Burke. Then we'll talk about how the Declaration of Independence should or should not influence contemporary constitutional interpretation, and have a great debate between 2 scholars of different perspectives, and culminate in a wonderful new biography of John Marshall, the Chief Justice who solidified the constitutional achievements of the framers and made the Supreme Court a co-equal branch of government. So as Robert Bork said when he was nominated for the Supreme Court, you are in for an intellectual feast, and I think it will also be a feast of constitutional education and debate and civic enlightenment. And with that introduction, I'm so excited to introduce 2 friends who've written this great new book, The Progeny, Justice William Brennan's Fight to Preserve the Legacy of New York Times v. Sullivan, and they are Lee Levine and Steve Wermiel. Lee is basically the leading First Amendment libel lawyer in the US. Anyone who has worked with him or knows of his reputation would turn first to him if we had a knotty question involving press freedom or defamation. He's an advocate as well as a scholar. He's a partner in the firm Levine, Sullivan, Cook, and Schultz. He's represented media clients in libel, invasion of privacy, copyright, and related First Amendment cases for more than 25 years, recognized by the best lawyers in America, and teaches at Georgetown University. Steve Wermiel, I've also known for many years. He is a professor of practice in constitutional law and associate director of the Summer Institute on Law and Government at the American University Washington College of Law, past chair of the ABA section of Individual Rights and Responsibility, writes for SCOTUS blog, and has written the great and definitive biography of Justice Brennan, liberal champion, which is also superb. So silence your cell phones, prepare to write down your questions on note cards. C-SPAN audience, start tweeting your questions to @ConstitutionCTR using the hashtag @NCC, or rather just NCC Bill of Rights, and we're going to get right to it. Lee, so we've just opened this beautiful new exhibit with one of the 12 original copies of the Bill of Rights. The first thing to stress is that the First Amendment, which you talk about in your book, was not the original First Amendment. There are two other amendments that appear at the top of the original Bill of Rights. One says Congress can't raise its own salary without an intervening election. That became the 27th Amendment in the 1990s. And the original Second Amendment said that there has to be one representative for every 50,000 inhabitants. If that had passed, I think there'd be 4,000 people in Congress today, as opposed to the 435 there are. But why is it that the First Amendment, which we think of as the most important, was not, to the framers apparently, the most important?
Well, there are a number of explanations for that possible. One is that there was, as you know, an original debate over whether or not we even needed a Bill of Rights in the Constitution. There was a sense that the original Constitution itself set out explicitly what government could do and what it couldn't do. And not what it couldn't do, but what it could do. And if it couldn't do, if it wasn't set out what it could do, then it couldn't do it. So that one of the things Congress couldn't do, some people thought, was pass laws that would abridge the freedom of speech or the press or interfere with religion or the rights of assembly. And we didn't need a Bill of Rights to make that clear. There were others, most notably James Madison and Thomas Jefferson, who thought that, no, that needed to be clear. We needed to list those things that the government could not take part in interfering with, those fundamental rights of being a citizen in a democracy. And first among those rights were the freedoms of speech and of the press and the freedom of religion and the other freedoms that are set out in the First Amendment.
That's a great and clarifying answer. And as you suggest, Madison certainly thought that free speech was important. The amendment that he considered the most important in his original list, which didn't pass, would have prohibited the states as well as the federal government from abridging freedom of speech and the rights of religious conscience. It took the Civil War and the passage of the 14th Amendment to achieve Madison's vision and apply the Bill of Rights against the states. But Steve, there was a crucial debate between Madison and John Adams at the time of the framing about the government's power to punish seditious libel, in other words, criticism of government officials, either false criticism or even true criticism. And tell us about the Sedition Act of 1798, which John Adams passed to punish not his critics of his administration, but not critics of his Republican vice president, Thomas Jefferson. So it was not exactly a neutral act. Tell us about what that act did and what James Madison's objections to the Sedition Act were.
Well, the authors of the First Amendment and its supporters believed they had won this fight, that in our new democracy, the notion of seditious libel was something that was very common in England. You could be punished for criticism of government officials, in England particularly the king, punished criminally or civilly for bringing ridicule or disrepute on the king. The proponents of the First Amendment thought they'd repudiated that idea and put it to rest, but in 1798, led by John Adams, Congress passed the Sedition Act, which basically did just that. It made it a crime to bring disrepute, to criticize the president in particular. And what followed were a number of prosecutions. There were a number of people jailed and fined for violation of the Sedition Act. This was a deep partisan divide. They were critics of John Adams. They went to jail. They paid the fines. As soon as Thomas Jefferson became president, he pardoned them and even subsequently had the government repay the fines. And we haven't heard much about the Sedition Act since then, until New York Times against Sullivan, which we'll get to shortly.
Great. So Lee, take us, the years between 1798 and New York Times and Sullivan involved some important cases about sedition around the time of World War I, when Congress passed the Espionage Act of 1917, which is actually being invoked today in threats to prosecute journalists, and said that criticizing the war should basically be illegal because it might lead to the bad tendency of leading people to resist the war. Holmes and Brandeis famously dissented from a series of opinions upholding those Sedition Act prosecutions, although Holmes changed his mind on that matter. But basically, tell us about the debates over free speech around the time of the Sedition Act, and how obvious was it to Holmes and Brandeis and others that the prosecution of sedition, of criticizing the government, did violate the First Amendment?
Well, it's interesting because, as you mentioned before, Jeff, the Bill of Rights did not apply against the states at all for a long time after the Bill of Rights were enacted, not until after the Civil War when the 14th Amendment was passed. So we have this long period where there's precious little law about what the First Amendment means and doesn't mean, because the federal government, by and large, after the Sedition Act, didn't try to do much to infringe what we would now commonly refer to as the freedom of the press or freedom of speech. It wasn't until World War I when, in the context of the war, the government started, under the guise of the Espionage Act, which was passed around the time of the war, to prosecute people who, looked at in hindsight, were doing little more than criticizing the government. A majority of the court in those days upheld those prosecutions. Justice Brandeis and Justice Holmes, as you suggested, wrote very eloquent dissents suggesting that that violated the First Amendment. It wasn't until much later, and ultimately in Sullivan itself, that the court backed the Brandeis and Holmes position. There were cases along the way, to be sure, that kind of put us along that path, but it wasn't until we got to Sullivan that the court, through Justice Brennan, put itself foursquare behind an interpretation of the First Amendment that both comported with what Jefferson and Madison were saying back in the Sedition Act days, Jefferson and Madison were saying back in the Sedition Act days, and with what Holmes and Brandeis were saying at the time of World War I.
I'm going to ask Steve about Sullivan in a second, but I want to understand, and I want our viewers to understand, what exactly seditious libel is, what libel is, and the differences between truthful and false statements. So libel, I gather, is a false statement damaging to someone's reputation, but at the time of the Sedition Act, couldn't the sedition be true? And I gather, according to British law, the greater the truth, the worse the offense. So tell us about the distinction between libel, which is false, and seditious libel, which could be truthful.
That's definitely true. The original seditious libel context, as Steve indicated, we inherited from England, was the speech only had to be disparaging of government, disparaging of the king, disparaging of his ministers and the people running his government. It didn't matter if it was true, and in fact, as you said, truth somehow made it worse because it increased the harm to reputation or the disrepute into which the government official was held. Common law libel, the kind of libel that became the centerpiece of New York Times versus Sullivan and all the cases that came after it, was slightly different. That was libel, that law of libel was the kind of lawsuit that you or I could bring against somebody who said something that injured our reputation. And in the early days, and in the common law of England that we inherited, truth was typically, not always, but typically recognized as a defense to libel, so that if you pled as a defendant, wait a minute, I said that, but it was true, and you could prove it was true, you won. That became a contentious issue later on as we struggled to try to figure out whether putting the burden of proving truth on a defendant in a libel case itself inhibited rights of freedom of speech from discouraging people who were unsure about whether they could prove the truth of what they said about someone in court from saying anything in the first place, which would tend to inhibit free speech according to that view.
Great. So we're going to be talking today mostly about libel, which is false but embarrassing statements. There's a separate area of law, which, as you suggested, involving truthful but embarrassing statements. That, I gather, is covered by the right to privacy and the question of intentional infliction of emotional distress, or if you put someone in a false light. And there's a huge debate today, and maybe we'll get to it at the end, about whether Europe can ban and require Google and Facebook to take down truthful but embarrassing statements that people have posted about each other. It goes under the rubric of the right to be forgotten, but that's a little bit down the road. Steve, New York Times versus Sullivan, March 29, 1960. The New York Times publishes an ad called "Heed Their Rising Voices," signed by celebrities including Jackie Robinson and Eleanor Roosevelt. Tell us what the ad says and what the objection of Mr. Sullivan was to this ad.
Well, the ad was a full-page ad in the New York Times, and it was aimed at trying to rally support for the civil rights movement, and particularly Dr. Martin Luther King. The ad said that law enforcement officials in Montgomery, Alabama, interestingly, it didn't name any officials, just said law enforcement officials, had harassed Dr. King, had padlocked the dining hall at the local college, had expelled students. It talked about student protests, singing "My Country 'Tis of Thee," and it ran through about 6 paragraphs of describing civil rights era activities in the Montgomery, Alabama area. L.B. Sullivan was the sheriff of Montgomery, Alabama, and basically said that the ad damaged his reputation and libeled him. The falsehoods were relatively minor. The dining room wasn't padlocked, but some students were not allowed to eat in the dining room. The police didn't ring the campus with a police line. There was just a strong police presence at the campus. The students didn't sing "My Country 'Tis of Thee," they sang the Star-Spangled Banner, things like that, you know, in sort of a common sense way, you would say couldn't really have damaged his reputation, but they were falsehoods. There were things in the ad that were clearly wrong. The problem there, Sullivan sued the New York Times for libel, for damaging his reputation, even though the ad didn't mention him by name. It presented a number of difficulties. For one, the New York Times in those days did not have a policy of verifying every fact in every advertisement. They verified that the people placing the ad were who they said they were, and that was as far as their responsibility went. So when it came to a trial, and the New York Times' only real defense was to say the ad is true, they really weren't in a position to do that. First of all, there were falsehoods, and second of all, they weren't really their falsehoods. It wasn't the New York Times saying it, it was the people who placed the ad saying it. So under the libel law in Alabama at the time, this was a very kind of complex, challenging situation.
Great. Well, not great, but thank you for describing it. Lee, the New York Times faces really serious damages if they're held liable. Remind me of how much they would have had to pay. It's something like $23 million in today's dollars and several million by the standards of the day. But describe what the common law of libel in Alabama was, and then describe what William Brennan's alternative was and what he held in New York Times versus Sullivan. Yes, please.
Excuse me. It's important to recognize that it wasn't only, Commissioner Sullivan who sued. There were 5 other lawsuits as well, brought by the governor of Alabama, by the mayor of Montgomery, by other city commissioners, all suing about the same ad, and all claiming, even though none of them were mentioned, that it was about them, and they all sued for $500,000 each, which is, Jeff mentioned, in today's currency is about $23 million. And if all of them had won, which they surely would have, the New York Times would have literally gone out of business. So it was very significant, and it was not an accident. This was a coordinated strategy to bring these lawsuits and attempt to chill the New York Times and other national media from shining a spotlight on what was going on in the civil rights movement of the South. The only reason they sued the ministers who placed the ad as well was to prevent, and this is a technical jargony thing of law, but it was to prevent the Times from moving the case from the Alabama state courts, where as a practical matter the fix was in, to federal court where there was a reasonable chance that the Times would have gotten a better shot. But there's one other important thing to recognize about this, which is that this lawsuit was not some sort of bizarre, cooked up, crazy theory under the laws that existed at that time. At that time, what Commissioner Sullivan was alleging was a pretty standard defamation case. If anybody out there read that ad to refer to Commissioner Sullivan and injure his reputation, he had a claim. And it shifted the burden of proving falsity from Commissioner Sullivan to the Times, who then had the burden of proving truth. Commissioner Sullivan didn't have to prove that he suffered any damages. Damages were presumed. He didn't have to prove that the New York Times was in any way at fault. Fault was presumed. So that by simply showing that it was about him and that the words tended to disparage his reputation, if a jury saw fit, he could recover $500,000. And that was the law, not just in Alabama, but in pretty much every state in the Union at that time. It just wasn't, people didn't think about the strategy of bringing cases like the ones that Sullivan and his colleagues brought against the Times for the purpose of inhibiting their freedom of speech.
So Steve, you've written the definitive biography of Justice Brennan, and this is just a magnificent book because Brennan was so centrally involved both in Sullivan and in all of its progeny, as you call it, which is the cases related to it that first expanded and then in some ways contracted on its promise. Brennan, as you say in this book, was not a personal fan of the press. He'd had some bad experiences where he felt like he'd been burned, and yet he wrote what Alexander Michaeljohn, the great First Amendment theorist, said was an opinion, an occasion for dancing in the streets for friends of the First Amendment, the most important First Amendment opinion, arguably, of the 20th century. You know, briefly, what was going on in Brennan's mind? How did he decide to resurrect Madison's vision of the First Amendment and overturn the Sedition Act, and how did he come up with the standard that he did?
Well, Brennan, in a sense, was and I mean this in a good way, was almost schizophrenic about the press. In his personal encounters with reporters, he didn't particularly like the experience. He thought reporters invaded people's privacy, didn't really show enough respect for the individuals they were writing about. But there was no greater believer than Brennan in the importance of a free press in a democratic society. He didn't have to like everything they did, but he understood that you couldn't really be an effective democracy without a press as a check on government, a press that felt free to really be able to write freely about what was going on in the country. And so that's the sort of dichotomy that was present here. In New York Times against Sullivan, he understood, and his colleagues did too, that one of the important things going on in this case was that the officials in Montgomery were basically trying to drive the northern press out of the South. They didn't want stories on the front page of the New York Times every day about the way civil rights protesters were being treated and about how desegregation was playing out in the early 60s. And if they could make it so costly for the New York Times and other northern media to do business in the South, that they might pull out. At the time of the case, the New York Times had already withdrawn their correspondent from Alabama in hopes of being able to avoid being served with the lawsuit. The other thing I might just note, and to add to Lee's earlier explanation, I think it's fascinating to remember the New York Times in those days had a circulation of about 600,000. 30 copies were sold in the entire state of Alabama. 0.01% of their circulation or something like that. Don't hold me to the math. But so Brennan understood right away both the civil rights importance of this case but also the opportunity to put forth this notion, the Michael John notion, the Madison and Jefferson notion, that a free press was essential to the functioning of a democracy. To do that, he came up with a new constitutional standard, one that had been used in a couple of state court decisions prior to 1964. The jargony term, which he later came to regret, is the phrase actual malice. A public figure, a public official, could not sue for libel unless that public official could prove actual malice. Actual malice meant that the statements were published with reckless disregard or knowledge of their falsity. So not just negligence, right? I could be a sloppy reporter, but not be intent on defaming somebody. I could just make a mistake. That's not reckless disregard. Brennan intentionally set a high standard, made it difficult. This is how it sort of ties into the notion of seditious libel, that we want to be able to freely report on government, on public officials, and only when reckless disregard takes place or knowing falsity can a public official then sue and recover for damages.
Okay, so as you say, Brennan came to regret the term actual malice because juries thought that it meant that the reporter didn't like the official, and that's not what it meant. It meant that A, you had to know that it was false, or B, publish it with reckless disregard of whether or not it was true or false. Lee, if God forbid I had a libel problem as a journalist, I would turn to you. So I want to now ask you about some contemporary applications of this standard. Right now, everyone is talking about the Rolling Stone story about the UVA alleged rape case, and many of my journalist colleagues have asked me, could the people who are written about at UVA sue on the grounds that this was reckless disregard for the truth since it was false? And I actually wrote right back to them, email Lee Levine. So I'm now asking you, could someone sue Rolling Stone under New York Times bestseller?
The question is, could they sue successfully,
Yeah.
I guess. And in some ways, that not knowing anything about the underlying facts other than what I read in the newspapers, it may well depend on who they are. And that gets to another major issue that the Supreme Court, with Justice Brennan leading the way, tried to deal with after Sullivan. Sullivan, of course, dealt only with public officials. And the rule in Sullivan was that a public official suing for libel or defamation had to prove actual malice, this knowledge of falsity or reckless disregard of the truth. In the years that followed, the court grappled with the issue of who else, if anybody else, had to prove actual malice. And Brennan led the charge, first in a series of cases, expanding it so that anybody who was a public figure, not just people who held public office, but people who were public figures, who the public had an interest in because of their own conduct, they too had to prove actual malice. And for a time, Brennan corralled enough justices to have a rule that any publication that addressed a matter of public concern, anybody who sued about that publication, whether they were a public figure or a public official or not, had to prove actual malice as well. That victory of Brennan's proved to be short-lived, and in 1974, Brennan found himself in the minority when a different majority of the court held no, private individuals, people who are neither public officials nor public figures, do not have to prove actual malice. They only have to prove negligence in order to recover, simply being not careful enough or unreasonable in how you went about your reporting. So getting back to the UVA case, if the plaintiff in the UVA case was a public figure, let's say the fraternity itself sued, it's a reasonable argument that a national fraternity is a public figure. They would have to prove that Rolling Stone published that article with either actual knowledge of its falsity or reckless disregard of the truth. A very high standard that Rolling Stone might not, somebody suing Rolling Stone might not be able to meet. On the other hand, if the person suing was a private figure, one of the people who was mentioned in the ad, mentioned in the story, or one of the alleged perpetrators, there's a reasonable argument that they're not public figures and that they would only have to prove negligence, which is a much easier standard to meet.
And on that negligence question, assuming as we read that Rolling Stone merely called up the alleged victim and didn't confirm her story, could that possibly qualify as negligence if they're viewed as private figures?
It could, and that would, of course, be for a jury to decide. One of the things that's pretty clear, although not universally clear, is that when you're a private figure and the standard is only negligence, which it is in Virginia, where presumably a lawsuit would be brought, courts do not make threshold determinations about whether this was negligent or not. It goes to a jury, and it's up to the people sitting in that jury box to assess the evidence and determine whether or not what Rolling Stone did or didn't do under the circumstances rose to the level of negligence. On the other hand, if it was a public figure suing, the issue of actual malice, the standard that Justice Brennan crafted in Sullivan, has universally been viewed by the Supreme Court and other courts as an issue of law, as a standard that in the first instance a judge has to apply. So one of the very important considerations and protections that the press has when the plaintiff is a public figure or a public official is that somewhere before a trial, a judge makes a determination of, is there enough evidence here by which a jury could find actual malice? And more often than not, the judge concludes, no, there isn't, and throws the case out, so the press never has to go through the burden of or expense of an actual defamation trial. That's less frequently the case when the plaintiff is not a public figure or a public official.
Okay, Steve, Lee has, by using the Rolling Stone case as an example, helpfully shown us how Sullivan evolved to distinguish crisply between public and private figures and set up different standards for them. I want you to further help us understand the evolution of the court. I gather that from the very beginning, there was a more First Amendment friendly position held by Justices Black, Douglas, and Goldberg that would have abolished all defamation laws that permitted liability for criticism of government or public officials. Would Black, and Douglas, and Goldberg also have forbidden libel for private figures or not?
I don't think they would have gone that far. The Black and Douglas, as is well known, took the position that when the First Amendment says Congress shall make no law, it literally meant no law, so that any law that permitted libel suits against the media for printing things about public officials would violate the First Amendment automatically. There wouldn't be an actual malice standard. There just wouldn't be any lawsuits, period. They didn't really go so far, I think, as to say they wouldn't ever allow any libel suits against private figures. But their presence on the court in these cases made it really challenging. I mean, the core of the court in the 1960s was this liberal core that included Brennan and Chief Justice Earl Warren and Black, Douglas, Goldberg. That would have been a kind of natural majority in these cases, but Brennan couldn't easily get the votes of Black and Douglas and Goldberg as they expanded Sullivan to apply to other kinds of public officials and then to public figures. So the interesting part of this book, I think, is that every one of these cases is from Sullivan for the next 30 years is just really hard fought. It's a constant tug of war. Sullivan looks like it creates this clear, broad, forceful principle about the First Amendment, and it does, but every iteration of it after Sullivan is just a battle and a struggle inside the court.
It is indeed, and the drama comes in your resurrection of the debates between the justices from their private papers. Lee, tell us about the criticisms of Sullivan. We had a phenomenal podcast on the actual 50th anniversary itself between Jeff Stone and Richard Epstein. And here's a plug, ladies and gentlemen, for our incredible We the People constitutional podcast. Every week, we're calling up the top liberal and conservative constitutional scholar in the country to debate the constitutional issue of the week. These podcasts, which you can find on iTunes and on our website, are getting up to 300,000 downloads a week. I want our C-SPAN viewers to check them out. And it's just a thrill to have such civil debate about such controversial issues. But Richard Epstein, Lee, basically said New York Times versus Sullivan was wrongly decided. We should have kept to the common law of libel and given public officials more ability to get civil recovery for calculated falsehoods. He embraced the position of Justices Clark and Harlan and Fortas. Tell us about what the criticisms of Sullivan were and what the more conservative justices would have preferred as an alternative.
Well, there were and are several layers of criticism. One is, and you hear it from Justice Scalia, who sits on the court currently, who always trots out New York Times versus Sullivan as his primary example of a case in which the Supreme Court got it wrong, because he views the issue of constitutional adjudication as looking back at what the framers intended, what the original meaning was. And he points to the Sedition Act and says, how can you say the First Amendment prohibits seditious libel when the ink was barely dry on the Bill of Rights when Congress passed the Sedition Act? Brennan's answer to that, of course, is, well, there was a disagreement at that time, and the author of the Bill of Rights, James Madison and Thomas Jefferson, thought differently, and that as Brennan says in Sullivan, the verdict of history is that the Sedition Act was unconstitutional when it was passed, and that most people, most informed people, recognize that. So that's one level of criticism. The other level of criticism is that as a practical matter, even as applied to public officials, having this kind of, as Justice Brennan put it in Sullivan, uninhibited, robust, and wide open debate has consequences. It makes people less interested in running for public office. It destroys reputations and careers when things are even when things are false. And it creates too much of a breathing space for truth. The other objection, of course, is as Sullivan got expanded outward and began to apply not only to public officials but to public figures. And as the court in 1974 said, the common law of libel, which was a tort or a claim that didn't require fault, suddenly required at least a showing of negligence, even by private people, that you were giving the press and others a license to destroy reputation, even when they had been negligent, even when they had done something wrong, and even when it was false, and even when there was actual injury to people's reputations. So that became the more contemporary argument against Sullivan.
Lee, Steve, as Lee said, the court expanded Sullivan from public officials to public figures and then to any newsworthy matter, but that raised some hard line drawing questions about who counts as a public figure. And there's the famous Gertz case where Justice Brennan advocated for a standard embraced by the lower court. I remember it from law school because it's such vivid language. He said, you're a public figure if you've thrust yourself into the vortex of public debate. And Justice Powell adopted a version of that standard and said, that's fair because public officials have more access to the media. If someone says something false about them, they can respond. Is that true in the age of the internet? Now everyone is a 15-minute celebrity, and everyone can thrust themselves into the internet vortex and also respond to falsehoods. How has the internet changed the definition of a public figure?
Well, I'm not sure the courts have entirely caught up to the changes that the internet has made, but the ability, both ways, the ability of something that you say about somebody to go viral instantly, and I turn to Jeff and say something nasty about Lee, and Jeff tweets it out, and it's in moments, thousands of people are reading it when I thought we were having a private conversation. But the flip side is Lee's ability to then send his own tweet out or use other means of communication to try to dispel whatever it was is there as well. So I think the original kind of notion that the court relied on of public figures and public officials having a better ability to be able to try to tell their side of the story really isn't as true as it was. I just have to add that as to the 1974 case that you talk about, Elmer Gertz had every bit that ability to go to the media and tell his side of the story, but the court didn't see it that way. I mean, he was a very prominent civil liberties lawyer in Chicago, but the court considered him to be a private figure.
Gertz, a Chicago lawyer hired to, it's like a Ferguson case. He was hired to represent a Chicago teenager killed by a Chicago police officer. The John Birch Society accuses him of being a communist, essentially, and the court holds that he is a private figure. Technology has its virtues and its challenges. Lee, I'm just curious, because you're the leading guy on this. How has the internet changed things? Do you represent private figures who allege that they've been defamed on the internet, and how do they fare under the negligence standard?
I represent people who are being sued by private individuals for things that are said on the internet. Well, it's very interesting, because if you talk to what, for lack of a better euphemism, I'll call Silicon Valley companies that are at the forefront of digital communications, the Googles and the Twitters of the world, they will tell you, well, you know, New York Times versus Sullivan and everything that came after it is very nice, and we're very happy to have it. But what's much more important to us is a law that Congress passed not too long ago called the Communications Decency Act, which has a section called Section 230, which provides that internet service providers and website hosts can't be sued for libel at all if they are simply transmitting what somebody else said. That is a huge expansion of the degree of protection, and I think it's fair to say that Google and Twitter and all of those things wouldn't exist today, or at least not in the same form, if they could be sued for false and defamatory statements that are disseminated by other people over their facilities. A website like the New York Times website or the CBS website, if they could be sued for what they put out on the internet, that content that other people created. And if you talk to folks in Silicon Valley, they will tell you that for them, Section 230 is the new New York Times versus Sullivan, because it has provided a degree of freedom much broader on the internet than a newspaper or a television station would enjoy for disseminating the same thing under Sullivan.
And that leads us back to Europe, which does not have a version of Section 230. Steve, if you don't mind, I'll ask Lee, because he litigates these cases. What is this? How easy is it to sue for libel on the internet in Europe without that immunity and without the protections of Sullivan?
Well, there's nobody who knows more about privacy and its intersections with the First Amendment than you, sir. But
that's not true. Not at all.
But I'll try to do my best. Europe has always valued privacy in competition with freedom of expression more than we have. It's a cultural thing. It's an embedded kind of thing in the DNA of folks who live in Europe. And as a result, their law reflects a much more forceful protection of privacy. And the most recent manifestation of it, which is increasingly troublesome to US companies, is this so-called right to be forgotten. And the idea is that if something is published about you, even if it's true, and you decide years later that I don't want that up there. I don't want when people do a search for my name to find out that when I was in high school, I attended a party and got really drunk and actually got hauled off by the police. So in Europe, you can now go to your local minister of data protection and say, I would like Google to take that down. And the European courts have said in all of the countries that are part of the EU, you have a right to have that taken down. It is a right to be forgotten, literally. And the big question now, which is about to be litigated, is whether or not Europe can force Google to take it down, not just on Google Spain or Google Denmark, but on Google US, the main Google website, so that you can't see it. So that you want to go back and research the history of somebody who's running for public office, you won't be able to find out what their indiscretions of youth or even their indiscretions of 20 years ago.
You've described it beautifully. The right to be forgotten comes from a French right called the droit à l'oubli, or the right of oblivion, which is completely French. It's straight out of Sartre. You know, the French all want to be forgotten, and Americans want to be remembered. But as Lee says, I think this is the biggest clash between American notions of free speech and European notions of privacy in the 21st century. If I object, say you're tweeting, or one of the C-SPAN folks is tweeting that this is a boring interview, and I object that this has violated my dignity, then Google has to decide whether or not I'm a public figure or whether or not the information is relevant to a matter of literary, scientific, or journalistic interest. And if it guesses wrong and a privacy commissioner in Dublin says that my dignity has been affronted, then Google is liable in some versions of the law to up to 2% of its annual income, which last year was $50 billion per incident. So you can see that this concentrates the mind. I hear some gasps in our good American First Amendment audience. Steve, what would Justice William Brennan have made of this proposed right to be forgotten?
I mean, I think he respected the right to privacy and helped advance it in many other contexts. But, I think he was a big believer in more information and in the marketplace of ideas. If he were going to be offended by the expansion of libel law beyond public officials, he had many opportunities to sort of voice that. And the vast expansion to public figures, to sports figures, to movie stars, to writers, never seemed to bother him. So I think he would kind of stay where he was, would stay on the same side.
I'm sure you're right. And what of the folks on the other side? You hear from people like Justices White and also Clark and Harlan and those other justices, more of a concern about dignity and more of a fear that the calculated lie had no social value and therefore should be prohibited. Might they be more sympathetic to these dignitary rights?
Well, yes, but I think in one sense they were, at least in Brennan's mind, I think they were talking past each other. I think right from the start, even in New York Times against Sullivan, inside the court, from reviewing the papers of the justices, there was discussion about the deliberate liar or the calculated lie. And Brennan's position all along was, we're not authorizing that. We're not protecting the calculated lie. We're not encouraging that in any way. We're trying to draw a line between legitimate mistake and freedom of reporting and freedom of discourse and the deliberate or calculated lie. But you had justices like White and others who firmly believed that that should be a matter of concern and that Brennan was in some way undermining our ability to go after the calculated liar, and Brennan believing that he was never doing that.
Excellent. I have more questions, but we have some phenomenal questions from our great C-SPAN viewers and from our phenomenal National Constitution Center audience. Once again, you can continue to tweet your questions to @Constitution Center, that's Constitution CTR, using the hashtag NCC Bill of Rights. And here is our first question from Twitter. Has adversarial journalism, a la Greenwald and Risen, historically been as threatened as it is today? Lee.
That's a very good question.
It is a very good question. Thank you, C-SPAN.
And the answer, I think, is probably not, in the sense that I think it is more under attack today than it has been in the past. Not because of defamation law. I think Sullivan has done a very good job of protecting the Jim Risens and Glenn Greenwalds of the world from being sued for libel. What has changed, however, is that they are more at risk for being hauled off to jail for attempting to protect the confidentiality of their sources, or for reporting what the government deems to be classified information and therefore puts them in line for violating something like the Espionage Act that prohibits publishing classified information that might do harm to the national security. And we have gone through a period in the last few years where the government has for the first time ever, gone on record in an affidavit filed in a federal court in the District of Columbia saying that a journalist could be prosecuted under the Espionage Act for publishing classified information it received from a source. But at the same time, we have since had the Attorney General of the United States state publicly that that will never happen so long as he remains Attorney General. As you know, he's submitted his resignation and he's not likely to be around very long. So we don't know how good that's going to be or for how long.
Steve, the Espionage Act, the heir to the Sedition Act of 1798, now being invoked by the executive branch, and a question about whether journalists can be prosecuted. What would Justice Brennan have said about a prosecution of a journalist under the Espionage Act?
Well, in the Pentagon Papers case in 1971, he was pretty firm that there was an extraordinary burden on the government to demonstrate a genuine threat to national security, an imminent, genuine threat, before somebody could be prosecuted for publishing truthful information. The Pentagon Papers were a truthful account obtained by the New York Times and then other media. The court was divided in a sense that some justices left the door slightly open, that there might be times when the government could meet that standard, whereas I think other justices made it seem as though the government would almost never be able to meet that standard. If you read Brennan really carefully, he was one of those who left the door ajar, but it was such a tiny crack that I'm not sure even a dust mite could come through the crack.
That's helpful. So now we've distinguished between false statements of fact, which is the common law of libel that we've been talking about, and now truthful but embarrassing statements, which are covered by the Pentagon Papers case, and which Justice Brandeis in the Brandenburg case said could only be suppressed if they were intended to and likely to cause imminent lawless action. That really is the crowning jewel of the American free speech tradition. It picked up on a standard that he had introduced in his concurrence in the Whitney case in the 1920s, but you really need, as you suggest, evidence that the speech not only is expressive advocacy, but that it's likely to lead to imminent violence, and that is something that America embraces and Europe most emphatically does not. Here is another question. Lee, could President Obama sue a publication for denying his birth in the United States?
He could. He could, and technically under libel law, if that was viewed as a defamatory statement that had somehow injured his reputation, he could win if he could show actual malice, that the person saying it either knew it was false or had reckless disregard for the truth. So far, at least, no presidents have brought libel suits, at least while they've been in office. So I think as a practical matter, it probably isn't good politics. I'm not sure the law stands in his way of doing that.
What would count, though? Someone just reads it on the internet, or even better, in Wikipedia, and assumes it's true? Does that count as, does that cover you for actual malice, or do you have to do some confirming of the fact?
That's an interesting question, and it comes up among other things in the Rolling Stone issue that you were talking about before. In one of the cases that we discuss in the book, Justice Stevens wrote an opinion for the court that seemed to expand the meaning of actual malice. It used to mean that you had to know that something was false, or you needed to know that it was probably false. Reckless disregard of the truth was interpreted to mean a high degree of awareness of probable falsity. In this case in 1989, Justice Stevens said, well, it could also be proved by deliberate avoidance of the truth. If you were kind of like the ostrich who stuck your head in the sand and didn't want to know whether it was true and just went out and said it, that might be enough evidence by which a jury could find reckless disregard of the truth. That concept has not really been unpacked in the law, but there is the notion that if you willfully blinded yourself to the truth and didn't do anything to try to figure out whether it was true or false, that might be enough. I think my own view is that as that issue gets litigated more and more, it's going to be demonstrated to not be enough because of the emphasis in Justice Brennan's opinions on actually having a subjective high degree of awareness of at least probable falsity.
Just apropos of what we were talking about at the outset, if we were a country that recognized seditious libel, the birthers might be guilty of seditious libel.
A good thing that Sullivan is on the books, and obviously the best way you can cover yourself against a claim of reckless disregard is to get your facts from the nonpartisan website of the National Constitution Center, constitutioncenter.org. Steve, was there any distinction made by the fact that New York Times versus Sullivan was an issue over an advertisement rather than an issue of reporting, as in the Rolling Stone example?
Well, in 1964, commercial speech was not entitled to any real First Amendment protection. The court didn't really view this as commercial speech, it viewed it as political speech because of the content of the ad. There was some discussion of it among the justices, but it was not really treated as a case. If it were today and it were not viewed as political, it was viewed as commercial, it would be subjected to a different First Amendment standard and entitled to somewhat less protection under the First Amendment.
And that was the Dun and Bradstreet case from 1983 that you say the landmark that wasn't. What did Dun and Bradstreet hold about commercial speech?
Well, Dun and Bradstreet draws a number of distinctions about private speech and particularly private commercial speech, basically being all bets are off. You can, if it's entirely private and commercial, there's not much First Amendment protection at all for the publication.
Great. I'm going to take the last question just because it brings us back to our celebration of our display of one of the 12 original copies of the Bill of Rights. The question is, why were the original first 2 amendments to the Bill of Rights dropped? Or perhaps put another way, why were they originally included in a Bill of Rights since they don't seem to affect individual rights? As Lee said so eloquently at the beginning, for most of the framers, most of the amendments in the Bill of Rights were either unnecessary or dangerous. Unnecessary because everyone agreed that human beings had certain natural and unalienable rights by virtue of their being human, and therefore you didn't have to write it down. And then dangerous because if you wrote it down, people might assume that if it wasn't written down, it wasn't protected. There were certain provisions regarding the apportionment in Congress, which were very important to the Congress people who proposed it, but less galvanizing to the ratifying conventions. And I think that's why the original First Amendment wasn't ratified until the 1990s. Prohibiting Congress from raising its own salary without an intervening election wasn't the most important cause for the Anti-Federalists. Similarly, the question of apportionment in Congress was not as galvanizing. And that's why the amendment that we consider the first was also the one that Madison considered the most important, along with his desire to forbid the states as well as the federal government from abridging freedom of speech and religious conscience. We'll pick up this fascinating discussion in our next talk, which examines the legacy of Thomas Paine and Edmund Burke. Paine, a great defender of natural rights in the tradition of John Locke, Burke, a defender of gradualism and tradition and the wisdom of the ages. We are going to take a 15-minute break and then return to our wonderful NCC Bill of Rights book fair. Before we do that, ladies and gentlemen, for starting off this phenomenal day with such intelligence and vigor and illumination, please join me in thanking Lee Levine and Steve Wermiel. Please go and have some coffee and check out the gallery. It's open now. You can see it, see the original Bill of Rights, try the interactive, and trace the spread of liberty across the globe. And we'll be back in 15 minutes. See you then.